So once you get past the LOI phase, obviously you're negotiating a lease, and at that point, that's where you're really involved in that.
Right. And normally I get involved once the letter of intent is finalized. If I'm tenants counsel, normally the lease is drafted by the landlord. It's almost always a landlord form. Sometimes more on the retail side for big national tenants, they have their own form, but typically the landlord drafts the first draft of the lease based on their form. And then you just get started. You talk to the client, find out what their needs are, take a close look at the letter of intent, and start drafting. Now, of course, you have to be mindful of economics, what size the space is, how many edits are appropriate. You can't get in the way of a deal as a lawyer. You have to be mindful of your client, and you have to advocate for your client. But if you're doing a 4,000, 5,000 square foot lease, you can't carve that lease up like a Thanksgiving turkey. You gotta be reasonable. What's reasonable in the marketplace? Hopefully the lawyer has experience and knows what is reasonable. Focus on the key terms. Now, if you're doing a 200,000 square foot headquarters space, and if the landlord form is a very heavy-handed form to start with, it would totally be common to have edits on every page of an 80-page lease. So, but again, on that size deal, the rent would be very, very high over the length of the term. So those that kind of time spent, legal time, would be entirely appropriate, and most, hopefully, definitely would add value in the long run for the client.
So more business leverage creates more opportunity to negotiate the terms in the form lease.
Right. Yeah, totally. I would say Virginia is a tough state for tenants overall. In other words, if you're in default, the judges in Virginia, the law in Virginia, in my view, favors the landlord. So there's always, even on a small deal, you definitely have to be mindful of remedies, default, exit strategies, assignment, subletting, things like that, which really come into play a lot. Where I always get calls a couple years later, not always, but it's not uncommon to get a call where something goes sideways, something unforeseen, and they say, is this in the lease? Where is this in the lease? We pull out the lease, find on page 35, you're covered. The landlord can't do that. They've got to give you written notice first, what have you. So sometimes people think, why would you mark up that lease that much? Well, it does protect the client. It does add value. At least that's the goal.